super pumped to bring this to you guys. This is a classic comedy, but there's a classic amount of crime in this video. Today, I'll go through every crime that I could spot in the movie Dumb and Dumber and react to it as a criminal defense attorney. I've been waiting for this moment for so long. Hi, my name is Lonnie Fish, and I'm a criminal defense attorney, and I'm here to analyze all of the crimes that I've spotted in the movie Dumb and Dumber. This classic comedy has a classic amount of crime. So without further ado, let's get right to it. In one of the first scenes, we see Jim Carrey's character drive through a bunch of lights. And what crime is committed here? For certain, he does some traffic offenses, but does it rise to the level of recklessness when he turns around and talks to somebody while not paying attention to the road? That'd be pretty tough to prove. What do you think? Let's watch.
Hey, something like that. There's really nothing to worry about, Mary. Statistically, they say you're more likely to get killed on the way to the airport. In a head-on crash or flying off a cliff or getting trapped under a gas truck. That's the worst. I have this cousin. Oh, I have it.
Lloyd, could you keep your eyes on the road, please?
Oh, we did see some people get hurt there.
Can't be too careful.
For certain, he caused that accident. You tell me, did he commit a reckless endangerment of another person? Here are the elements to that crime. Moments later, Lloyd drives into the back of another car and he doesn't stop to report the accident or exchange information. That is a misdemeanor of the third degree. In this instance, it's called accidents involving damage to attended vehicle or property. It's a misdemeanor of the third degree, which in this instance is punishable in jail for up to 1 year, and you can be fined up to $2,500. Let's watch.
Goodbye, love. Bye.
Seems like Harry's attention was on Mary and not reporting the accident. Just moments later, we see Harry running through the airport and grabbing the briefcase. Is that a crime? Well, the true lawyer answer is that depends. Very little known fact that there is a crime in Pennsylvania called theft of property lost, mislaid, or delivered by mistake. So essentially, if you come into control of property that somebody else leaves behind, if you know it's been lost, mislaid, and delivered under mistake, and then you keep it with intent to deprive the owner of receiving that property, that you could be guilty of a crime. However, here, I believe that Harry had every intention of returning that briefcase to Mary, and therefore he took more than reasonable enough amount of measure to restore that property to her. So I would suggest to you at this time he's not guilty of theft, but it could be construed that way. Let's watch, and you tell me.
There's our payday. She left it. Let's go.
Excuse me! Coming through! Move it or lose it, sister!
Those are more than reasonable measures that he took to try to return that briefcase to her. I'd say at this time, he's not guilty of that offense. Moments later, Harry runs with the briefcase through the airport, and after it's communicated to him that he can't go through a particular area, he goes through anyway. Here, I would suggest that he's a defiant trespasser. What that means is that he has known that he did not have license or privilege to do so. He entered or remained in any place where notice against trespass was given to him. In this instance, by actual communication. I would suggest when the airline employee said to him, "Sir, you can't go in there," that would be actual communication to him. Let's watch.
Sir, you can't go in there. It's okay. I'm a limo driver.
It's not okay that he's a limo driver. He is guilty of defiant trespass. Being a limo driver is not an affirmative defense to defiant trespass, and it did not give him license to go into that tarmac. Moments later, Harry and Lloyd are tracked down by the gas man and his property, and they hear a knock on the door. And what do they see? Nothing only but the gas man. You can faintly see him loading a gun. I hope he has a license to carry that gun, because if he doesn't, he could be committing a felony or a misdemeanor. Additionally, if he's a former convict, which, judging by his actions, he may be, he actually would be committing another special crime, which is called with persons not to possess. Let's watch.
There's two of them. One of them's not. Did you pay the gas bill?
And I hope he renewed his license to carry, or he has one, because that could be several felonies or a misdemeanor. Moments later, the gas man breaks in, and the question is he committing a burglary or just a trespass? I would suggest he's committing a burglary, because a person commits a burglary if, with the intent to commit a crime therein, they enter a building or structure that's separately secured or occupied that is adapted to overnight conditions. In this situation, they're very lucky they could have been charged under 3502 section A1, but Harry and Lloyd just escaped. So the occupied structure in the portion thereof is actually, no one is present. They suffer a little bit less of a penalty here, but in my mind, they had an intent to commit a crime. That is, retrieve that briefcase and continue their kidnapping for ransom. So I would suggest that they are guilty of burglary. Let's watch.
Briefcase ain't here.
He must have taken it with him.
Most unfortunately, the gas man decides to commit another crime, that is cruelty to animals. But how much time is he looking at, if at all, for this? Let's discuss it right now. Well, the gas man is looking to up to 2 years in jail because of the cruelty to animals. It's a misdemeanor of the second degree. Essentially, it's defined as the following. It's cruelty to animals defined as the following: that a person commits an offense if the person intentionally, knowingly, or recklessly ill-treats, overloads, beats, abandons, or abuses an animal. I would suggest in this instance, ripping the head off of a bird is abusing an animal, and therefore he has committed that crime. Later that night, upon the return, Harry and Lloyd decide to cut their losses and get some essential items for the night. Harry accidentally leaves his wallet behind, and he claims that he's robbed by a little old lady.
Where's the booze?
I got robbed by a sweet old lady on a motorized cart.
Was that a robbery? Well, you tell me. Robbery in Pennsylvania is defined as the following: that somebody, if in the course of committing a theft, they have to either inflict bodily injury, threaten bodily injury, commit or threaten to commit another felony of the first or second degree, inflict bodily injury upon another, or threaten another with intentionally putting them in fear of immediate bodily injury, or physically taking it from them. She didn't commit a robbery, but she certainly committed a theft. The gradation of that theft, if the items in that wallet were between $200 and $2,000, is a misdemeanor of the third degree. Lloyd admits that he traded a sack of marbles, some baseball cards, and a dead bird Petey to a blind kid for some money. This is theft by deception, don't you think? Let's watch.
We're really doing it though, aren't we, buddy? Like, hey, bird to a blind kid? Lloyd, what do you... Petey didn't even have a head.
Harry, I took care of it.
Pretty bird. Yeah, can you say pretty bird? Pretty bird. Yes, pretty bird.
He took care of it with some deception. In Pennsylvania, theft by deception is defined as the following: is that a theft, if somebody intentionally obtains or withholds property of another by deception. Person deceives if he intentionally creates or reinforces a false impression. In this case, by taping the head of Petey onto his body, he's creating the false impression to the blind kid that he's actually receiving a live bird. Therefore, he's guilty of theft by deception. While eating some lunch on the road, Harry has to toss some salt over his shoulder, and unfortunately, it strikes sea bass. Is that a crime? I don't think so. I think he did it by accident. There's no injury, so we don't have a simple assault or a threat to commit an injury. It could possibly be harassment, but harassment requires that the actor have the intention to harass, annoy, or alarm another. Here, all Harry was trying to do was throw some salt over his shoulder. He did not have that specific intent to harass, annoy, or alarm anyone, including Seabass. So I would suggest that because there's no injury, he is actually not guilty of any crime, including harassment. Let's watch.
Driving across the country, the last thing we need is bad luck. Quick, toss some salt over your right shoulder.
What the hell?
Not the smartest of ideas to mess with Seabass, but also not a crime. In return, Seabass decides to hock a loogie into Harry's burger. That is a crime. I would suggest that that's criminal mischief. Let's talk about criminal mischief. Person is guilty of criminal mischief if they damage tangible property of another person intentionally, recklessly, or by negligence. And I would suggest that Harry's burger is his property, and therefore he is guilty of criminal mischief. The valuation is less than $150 because I don't think that burger is that special. So therefore, it's a summary offense. Let's watch.
Who's the dead man that hit me with the salt shaker?
I think he had plans on eating that. That was a criminal mischief. As a result of all this, Harry and Lloyd concoct some plan that they saw in the movie theater. Again, we talk about what is this crime? The crime is obviously theft. They get away with all this merchandise. They tell the restaurateur to put it on the tab of Seabass. But let me ask you, who do you think the victim is? Is the victim actually Seabass, or is it the restaurant? I would suggest that Seabass is not on the hook for any of these items, that this was a crime of theft, unlawful taking, or theft by deception that was committed by Harry and Lloyd. So I don't see why Seabass would be so upset. He can't possibly be on the hook for this. Just to talk to you a little bit about civil law as a bonus. Let's watch.
Put it on their tab. They're very nice.
Seabass said that.
Well, if that guy at the table over there is Seabass.
All right, that's what he wants.
These one or two.
Assuming all those items, the Boilermakers, the sandwiches, all added up to over $200, that too is a misdemeanor. But certainly Seabass is not on the hook for all of that, just because somebody tells the restaurateur that they're on the hook for the bill. So unfortunately, they detrimentally relied on that, and Seabass is not on the hook for that. Moments later, Lloyd unfortunately really has to urinate, and instead of pulling over and letting him go because they're trying to evade authorities, he decides to urinate inside the car. Even if there was some sort of local ordinance against public urination, that isn't in public. In fact, I don't think he even committed indecent exposure. Indecent exposure is when a person exposes his or her genitals in any public place or any place where where there are present other persons under the circumstances in which he should have known that his conduct is likely to offend, affront, or alarm. Here, I don't think that we have met those elements. So I would suggest that when Lloyd decides to urinate inside of a bottle, he's not committing any crime, or possibly no public urinations if there's a local ordinance against it. Let's watch.
Gotta go. What am I supposed to do? Well, whiz in one of the empty beer bottles in the back. Just on the floor. Just get one of. What? Watch the seat. Watch the seat. Yeah. Uh-oh. What? What's wrong? The bottle's almost full. I'm still going. So stop going. I can't stop going once I started. It stings. Quick, give me another bottle.
Person is guilty of indecent exposure if that person exposes his or her genitals in any public place where another person's present, which under the circumstances he or she should know that the conduct would likely be offend, affront, or alarm. In this particular instance, I would suggest to you that that's not the case. If charged with this offense, government will not be able to meet their burden. Moving forward, we finally learn as to what is actually happening with Mary Swanson's husband and this briefcase. And the reality is we learn of a plot for kidnapping. Kidnapping in Pennsylvania is defined as the following: that if someone unlawfully removes another a substantial distance under the circumstances from the place where he or she is found, or if he unlawfully confines another for a substantial period in a place of isolation with any of the following intentions. Number one, to hold for ransom or reward, or as to shield or hostage. Two, to facilitate commission of any felony or flight thereafter. Three, to inflict bodily injury or to terrorize the victim of another. And four, to interfere with the performance of public officials of any governmental political function. So in this instance, he was being held for ransom or reward. So for sure, this is kidnapping. Let's watch.
It just doesn't make sense. I left the money exactly where they instructed me to.
We've definitely learned about this ransom plot for sure, and that is kidnapping, specifically of kidnapping for ransom. I do want to talk about this dream sequence. This whole movie is a dream. But Lloyd watches that waiter flirt with his date, Mary. He then gets up in a fighting pose and they begin to fight. I would say at this time, there is no self-defense. Self-defense requires some sort of duty to retreat. And plus, apparently he's the instigator. There is no law against flirting with someone. But what begins as a mutual fight, a simple assault, turns into what I would argue an aggravated assault. You see, simple assault is normally graded as a misdemeanor of the second degree, and it can be graded as a misdemeanor of the third degree if there is a fight or scuffle that is entered into by mutual consent. However, Harry takes it next level and breaks the arm of the waiter, which in my estimation takes this to an aggravated assault because he attempted to cause serious bodily injury or actually caused that serious bodily injury. There's no such thing as a mutual aggravated assault. Therefore, in my mind, he is guilty of aggravated assault. Let's watch. Not just the arm, but in the groin area. If he lost any functioning there, he could also be guilty of aggravated assault. Then what happens is he fights the chef, and we know for a fact that the chef dies. Who can live without a heart and coming out of their chest? Of course, we know the chef is dead, but the question is that murder? I would say during a mutual fight, for sure, it's going to be hard to argue self-defense. Again, there's a violation of the duty to retreat. But was Lloyd provoked? Voluntary manslaughter is when a person kills an individual without lawful justification. They commit voluntary manslaughter. The crime, they are under a sudden and intense passion resulting from serious provocation by the individual killed. I would strongly suggest to you that the waiter just came out being angry about what's going on is not serious provocation. Furthermore, even if you were going to stretch and say that flirting with Mary was that serious provocation, he will be mistaken. For sure, we also, in case you were wondering, the difference between murder in the first degree and murder in the third degree is that I would also suggest, I also need to talk about what type of murder this is. Is this a murder of the first degree, or is this a murder of the third degree? Well, very simply put, murder in the first degree is an intentional killing. Murder in the third degree is one that's done with malice. In this particular instance, I would suggest to you that grabbing somebody's heart out of their chest shows an intent to kill, because nobody could live after the heart was ripped out of their chest. Later, while on the trail to find Harry and Lloyd, the gas man finds himself in a telephone booth. For all you young people that don't know what that is, before cell phones, we actually had to put coins inside of public phones to make phone calls. And the annoying guy who we never find out what his name is, who's waiting his turn patiently to use the phone, gets smashed in the face by the gas man. It used to be that a single punch could not be aggravated assault. However, new case law has shown that you can commit an aggravated assault with a single punch. But I would suggest that even if that single punch case, which is Commonwealth versus Alexander, was still around, that this is a little different because that punch is through a piece of glass window. That punch is through a single glass window. So that's not just like your everyday bar fight. Let's watch.
That's not your problem. Get off the phone. Get off the phone.
Now, with minor injuries, that's just a simple assault and maybe a criminal mischief of breaking that telephone booth. But we'll see. But we never find out what his injuries are. So depending on the injuries, it's simple. It's simple assault or aggravated assault plus criminal mischief for breaking the telephone booth. Here is one of the most interesting scenes to talk about. This case for that overruled Alexander is called Commonwealth versus Burton. That suggests that you do not need that. A single punch can certainly equate to aggravated assault under certain circumstances. This is definitely the most interesting scene to analyze in this movie. We find out that Mental has some sort of pre-existing medical condition, whether it be an ulcer or gas or some sort of digestive issue. And it's not clear whether or not Harry or Lloyd were aware of that when they put peppers inside of his burger. Here, we talked earlier about murder when Lloyd ripped the heart out of the chef's body. But here, there's definitely no specific intent to kill. And the question becomes, was this malicious? At one point, Mental asks for his pills, and then unbeknownst to him, Harry gives him rat poisoning. We all know that that was not what he intended to do. He intended to give him his pills, but which I would suggest that because Mental had rat poisoning in there, that may have been some sort of intervening cause aside from the malice. Now, if the poisoning never occurred and Mental had just died as a result of the peppers within the burger, I would suggest that the crime that was committed is involuntary manslaughter, because that's not quite reckless to put peppers inside of somebody's burgers. I've had that happen to me, not quite like that, but I've had people put wasabi in some of my things. So involuntary manslaughter is really the proper crime here. So involuntary manslaughter is when, as a direct result of doing an unlawful act in a recklessly or grossly negligent manner, or in the doing of a lawful act or grossly negligent manner, he causes the death of another person. I would suggest that if there was no intervening fact of the rat poisoning, that this could be involuntary manslaughter. In this particular instance, I don't think Harry and Lloyd are guilty of any crime. There's no way they could have known that there was rat poisoning within that bottle. In fact, if anything, there's no way they could have known that. And if they were arrested and charged with murder or even involuntary manslaughter, I would argue that that was an intervening cause, and that caused the death of Mental and not the peppers inside of the burger. Let's watch.
You run around nowhere after I dump a little rat poison in there, Shirley Temple.
Feeling better, girls?
Yes, much better. Thank you for asking. So what are you going to ask them? Vacation?
Are you okay, man? It was just a goof. My Elsa. My pills.
Maybe somebody should call an ambulance.
You get the pills. Don't worry, I know CPR.
I'll get the pills.
Out with the battery. Out with the battery. This is a lot easier if you just lay back. He's resisting me. Pills are good. Pills are good.
Better? Mustard, ketchup, and mustard, that helps us.
Not sure if that was really CPR. That's not how I learned it to be, but for sure, that's not murder. There was an intervening cause to their goof. While on the road, Harry and Lloyd stop at a gas station, and Harry has some bad timing, has another encounter with Seabass. Thank God Harry was there to intervene, because he stopped what could have turned into something much more than harassment. I only want to think about what would have happened to Harry. Let's watch.
I'll show you a happy place. Here's your happy place.
That's some good timing. How about that? We don't also, on a side note, have any reckless burning or arson, because Harry only set his own pant leg on fire. If he had set anything else on fire, we would be talking about arson. Let's talk a little bit about arson now. Arson is when you intentionally start a fire or cause an explosion, or if you aid, counsel, or pay or agree to cause for someone else to cause that fire. Talking about reckless burning, which is what this could possibly fall under, is when a person intentionally starts a fire or causes an explosion recklessly. So here, in this instance, if something else was caught on fire earlier when Harry lights his cigarette on his pant leg, that could be a reckless burning, but for sure not an arson. At some point later, the rubber meets the road, and Harry and Lloyd get desperate and decide to start borrowing the money within the briefcase. They leave an IOU for several things that they buy. I would suggest in this instance, they went from not committing a theft to committing a theft. That even though it was their intention was to not deprive the owner of the money, that they would have never have had the ability to get that money back to them for that Ferrari or Lamborghini, whatever it is. And here, in that instance, now we've committed theft of lost or mislaid property. Let's watch.
Mrs. Charles and I, when they were together, used to frequent the hotel constantly.
We'll take it.
But I would say, let's talk about the grading of this theft. I would actually say that the grading of this theft is most likely a felony of the first degree, which is rarely seen because usually thefts aren't for over $500,000. In this particular instance, there's almost no money left, and we do know that the briefcase had $1 million in it. So I would suggest it's a felony of the first degree. Anything between $200, $100,000, and $500,000 is a felony of the second degree, and anything more than $2,000 is a felony of the third degree. So therefore, most likely, this theft that Harry and Lloyd have committed is a felony of the first degree. They better watch out. There's a lot of animal cruelty in this particular movie. Here we have some birds being shot.
Bubbly. You're gonna be my best man, Harry.
Oh, good.
I promise.
Thank you.
You have just earned yourself a seat at the head table, pal. We already got the tuxes.
Not sure how you get two birds with one cork, but that's one magic cork. That's 2 counts of animal cruelty, and not an intentional shot, but it certainly is reckless to open a champagne bottle and pointing it at a bird. He is guilty of a misdemeanor, 2 misdemeanors of the 3rd degree. In one of the most iconic scenes of any comedy, Lloyd is extraordinarily jealous that Harry has gone on a date with Mary. And what he does is that he puts just a little bit too much of Turbolax into Harry's tea. I would suggest that for sure we have a crime called possession of an instrument of crime here. That would be the Turbolax. Now, the reason I bring this up now is that I've seen many different things be an instrument of crime. One time I had a soda can, and another time I've seen a cat. Criminal instrument is defined as anything specially made or specially adapted for criminal use. In this particular instance, the Turbolax is not specially made for criminal use, but in this instance, it was adapted to criminal use. What crime was committed when Lloyd put the Turbolax in Harry's tea? Let's discuss. What's interesting to think about in this scene is whether Lloyd caused serious bodily injury. It's obvious that he didn't intend to cause bodily injury. He just intended to cause a lot of discomfort. So at a minimum, we have some sort of harassment because there's an intent to annoy or alarm. But I want to talk to you a little bit about what serious bodily injury is. Serious bodily injury is where bodily injury creates a substantial risk of death, or which causes serious permanent disfigurement or protracted loss of or impairment of the function of any bodily member or organ. So, if the Turbolax caused a permanent disfigurement or a protracted loss of or impairment of the digestive system of Harry, we actually could have serious bodily injury. Not sure if that's possible, but sure was a lot of Turbolax in that tea. Let's watch.
Hey, Harry, old buddy, old pal. Yeah? Will you join me in a good luck toast before you head out? Oh, sure thing. Whatever you think will help your chances. Yes, sir. You know why I like you, Harry? Because you're a regular guy. Yep. That's why I want you to stay regular. 1/2 teaspoon for fast, effective relief.
Again, and depending on how long that relief is whether or not we have serious bodily injury rising to a aggravated assault. Let's continue watching. Why not?
What was all that 1 in a million talk?
Aren't you gonna invite me in?
Case, my friend Harry and I have every intention of fully reimbursing you.
Open it up. Open it up!
Go ahead. Open it up. Do what he says. Harry.
all the money?
That's as good as money, sir. Those are IOUs. Go ahead and add it up. Every cent's accounted for. Look.
That doesn't get him out of this theft, all the IOUs for the record. But let's move on. At some point, Harry comes in and takes a couple shots to try to save everybody. Here, one would argue justification of others. I would suggest that he was empowered by the police by given a firearm, even though if he had a license, he would have a nice justification defense, or even suggest that he is acting as a law enforcement or police officer, which wouldn't require him to have a license. And when he was shooting at Nicholas, really bad miss, I would suggest that he would have been justified, that they were being threatened with immediate serious bodily injury, and that he was protecting them. Let's watch.
Oh no! You killed my best friend, you bastard!
Let's try that again. When Nicholas shot at Harry, he was certainly committing an attempted murder. Attempted murder is when you have the specific intent to kill, and the law has clearly shown that taking a deadly weapon to a vital part of the body, that is specific intent to kill. So in instances where somebody pulls a trigger and either they miss, or in the alternative, the gun jams, you could be found guilty of attempted murder. Section 506 of Title 18 suggests that the use of force upon or towards the other person is justifiable to protect a third person when the actor would be justified under Section 505 relating to rules of self-protection. And here in this particular instance, for sure, Harry was being threatened, and so was Lloyd being threatened with death or serious bodily injury. He had no way to retreat because Nicholas was pointing a gun at him and standing in the doorway. So certainly use of those shots was justified. Here in this instance, Section 506 of Title 18 talks about defense of others and self-defense, but in order to defend others, you have essentially suggests the law says the following, that the use of force towards the person is justifiable to protect a third person when the actor would be justified under Section 505 relating to use of force in their own self-protection, meaning that if somebody else is threatened with death or serious bodily injury, you can use force to protect them. Here in this particular instance, there was already an attempt taken on his life. Nicholas is standing between him and the door, and we certainly have that threat, and there is no duty to retreat. I hope you watched all of this. I've been waiting a very long time to do this, and when Dumb and Dumber came out, I was a young child, and I love that movie very much. If you've had fun, please like and subscribe our channel. I'm Lonnie Fish, and I'm from the Liberty Law Team. If you've been injured or arrested, feel free to call us at 267-THEY-WIN. Thank you.